The reality is Pam Bondi has obfuscated for months. She first said there were no more documents to be seen. Now she's admitting and releasing hundreds of thousands of documents, but it is an incomplete release with too many redactions. The Justice Department's document dump this afternoon does not comply with Thomas Massie and my Epstein Transparency Act. They released one document from a New York grand jury of 119 pages, totally blacked out. And our law requires them to explain redactions. There's not a single explanation for why that entire document was redacted. We have not seen the draft indictment.
This just happened. It is late afternoon in Washington, D.C., and we are witnessing the beginning of a historic collision between the Department of Justice and the United States Congress. The situation involving Attorney General Pam Bondi has shifted from political maneuvering to a full-blown constitutional crisis. This is no longer just about delayed documents or partisan bickering. We are looking at the potential collapse of institutional norms that have held the government together for decades. The trigger for this escalation occurred just hours ago. The Justice Department released a document dump regarding the Jeffrey Epstein files that was so heavily redacted and incomplete that lawmakers are calling it an insult to the legislative branch. At the exact same time, reports are confirming that Bondi has sent a letter to the governor of Minnesota that legal experts are describing as extortion. These two events have merged into a single dangerous narrative. We are talking about the weaponization of the federal government against state officials and the deliberate defiance of federal law. The stakes here involve the personal financial ruin of the Attorney General through a rare process called Inherent Contempt and the survival of the Justice Department as an independent body. Here is exactly what is happening right now. We need to go through the facts of this situation step by step because the details are moving very fast. The reality on the ground is that Pam Bondi has been delaying this process for months. Initially, her office claimed there were no more documents to be seen regarding the Epstein network. That position has now collapsed. Today, she is admitting to the existence of these records and releasing hundreds of thousands of documents. However, this release is incomplete. It is filled with heavy redactions that hide the most critical information. The document dump that occurred this afternoon is in direct violation of the Epstein Transparency Act. This is a law written by Representative Thomas Massie and Representative Ro Khanna. They were very specific in the text of the legislation. The Justice Department released one document from a New York grand jury.
Just a week later, Maxwell was moved to a more permissive prison camp in Texas. Why was she moved just days after you interviewed her, Mr. Blanche?
So that's a Bureau of Prison Security issue that I will not talk about.
Did you have anything to do with it? Did you have anything to do with it?
It was 119 pages long. Every single page was blacked out. The law requires the Department of Justice to explain why they are hiding information. In this release, there is not a single explanation for why that entire document was redacted. We have not seen the draft indictment. We have not seen the list of associates. This is a major update on a story that has been building for a long time, and the situation is getting very real. Pam Bondi is Donald Trump's Attorney General. She is now facing actual consequences for how she is running the Department of Justice. This goes far beyond angry comments from opposition politicians or letters that get ignored. We are talking about a process known as inherent contempt. This is a procedural tool that could fine her personally for every single day she refuses to comply with the law. We are also seeing articles of impeachment being drafted right now. There is a bipartisan group of lawmakers who are completely finished with her refusal to release the Epstein files. They are also alarmed by her attempts to pressure state governments into following federal orders. The pressure on Pam Bondi is coming from two different directions at the same time. Both of these fronts are creating serious legal risks for her personally. The first front is the Epstein files. The Transparency Act passed Congress with overwhelming support from both parties. It required the Attorney General to release all unclassified records by the 19th of December 2025. Bondi ignored that deadline. The Department of Justice has released less than 1% of the documents they possess. They are in open violation of federal law. They have even told a judge that they will remain in violation for the foreseeable future. Thomas Massie is a Republican from Kentucky. Ro Khanna is a Democrat from California. They wrote this law together. They are furious about this violation. They are now drafting the Inherent Contempt resolution. This is a tool that many people do not know about. Usually, if someone ignores Congress, the House has to ask the Justice Department to prosecute them. Bondi is not going to prosecute herself. Inherent contempt allows the House to bypass the courts entirely. The House can fine officials directly. It only needs a simple majority to pass. They are preparing to use this against Bondi. It gets worse for her. House Democrats are publicly discussing introducing articles of impeachment. They are citing her willful violation of the transparency law. They are also citing her scrubbing of the document release to protect the president. This includes removing at least one image of the president with Jeffrey Epstein and Ghislaine Maxwell from the official website. Senator Adam Schiff has called these omissions a willful violation of the law. He stated she should testify under oath to explain why documents are being redacted and why images are being removed. Then there is the second front. This is the situation in Minnesota. This creates a new category of legal problems for Bondi. Federal agents recently killed an ICU nurse named Alex Prey during an immigration raid in Minneapolis. After this event, Bondi sent a letter to Governor Tim Walz. Legal experts are calling this letter straight blackmail. In the letter, she demanded access to Minnesota's Medicaid records. She demanded SNAP benefits data. She demanded full voter registration records. She also insisted that Walz end sanctuary policies. She framed this as a condition for restoring the rule of law. This is significant. The Attorney General is telling a state governor to hand over welfare records and voter rolls. The implication is that if he refuses, the federal government will not stop using armed agents to pressure his state. Governor Walz responded aggressively. He said Bondi should focus on the 2 million unreleased Epstein documents instead of trying to extort Minnesota. His lawyers told a federal judge that Bondi's letter proves the Department of Justice is using 3,000 armed federal agents as a tool of coercion. They are trying to win policy changes they cannot get through the courts. This is not normal law enforcement. This is using the power of the federal government to force states to comply with a political agenda. Reports from The Atlantic have published a devastating analysis of what Bondi has done to the agency. They describe her as an attorney general who has transformed the department into an arm of the presidency. She has fired over 230 career attorneys. She has dismantled key civil rights units. She has turned the department into a personal enforcement squad while ignoring laws passed by Congress. Mother Jones is listing her actions as part of a growing catalog of abuses. This includes the Epstein stonewalling. It includes pardons related to January 6th. It includes political targeting of critics. This is the update. Bondi is not just facing criticism. She is facing inherent contempt. She is facing impeachment articles. She is facing lawsuits from states she is trying to coerce. The walls are closing in on the legal strategy of the administration. The Epstein Files and the Minneapolis situation are giving her opponents concrete legal hooks to pursue her removal. Let us look deeper into these situations. The details reveal the level of legal jeopardy Bondi has created. The Epstein Files Transparency Act was a rare moment of bipartisan agreement. Massie's a libertarian who rarely works with Democrats. Khanna is a progressive. They came together because they believe the public deserves to know the truth about the illicit exploitation network run by Epstein. The law was simple: release the records. No exceptions. Bondi looked at that law and essentially said she does not care. The deadline passed. The Department of Justice released about 120,000 documents out of more than 2 million. That is a tiny fraction. They claimed they suddenly discovered over 1 million additional documents and would need years to process them. This looked like a delay tactic designed to run out the clock. Critics noticed that the documents being released were redacted in suspicious ways. The removal of the image involving the president was a major red flag. The administration issued an unsigned memo claiming there was no client list. Staff were allegedly instructed to flag any documents mentioning the president by name. Massie and Khanna are not accepting this. They announced the Inherent Contempt resolution. This tool exists for this exact situation. The House can impose daily fines on officials who refuse to comply. These fines can add up to thousands of dollars per day. This hits her personal bank account, not the department budget. It is designed to create personal consequences. The Minnesota situation is where Bondi may have overplayed her hand. After the killing of Alex Prey, tensions exploded. The president threatened to invoke the Insurrection Act. He demanded investigations into Governor Walz. Federal agents were conducting operations throughout the state. Into this volatile situation, Bondi sent her letter. She demanded state data on vulnerable populations. She demanded voter registration records. The implication was clear. If Minnesota did not comply, the federal operations would continue. Governor Walz called the letter a collection of falsehoods. His administration filed documents arguing that this constitutes illegal pressure. Using federal law enforcement power to extract policy concessions from state governments is not acceptable. It is the kind of abuse impeachment was designed to address. When Bondi sends letters demanding voter rolls in exchange for backing off with armed agents, she is not acting as a neutral officer. She is acting as a political enforcer. The Atlantic analysis describes a systematic transformation. She has fired the professional staff who maintain independence. She has replaced experienced prosecutors with loyalists. She has gutted corruption units. Mother Jones argues these are impeachable offenses. Each action might be dismissed alone. Together, they paint a picture of an attorney general who has abandoned independence. This is why the pressure is intensifying. The Epstein files give her opponents a clear statutory violation. She is factually in violation of a law passed by Congress. The Minnesota letter gives them evidence of coercion. Together, these create a compelling case that she is unfit for office. The question is whether consequences will materialize. Inherent contempt requires only a simple majority in the House. The legal hooks exist. The evidence is there. We need to analyze why these specific mechanisms, inherent contempt and the Minnesota standoff, matter so much in the broader context of political history and institutional power. This is not just about one attorney general or one president. This is about the fundamental architecture of how the American government functions. First, let us look at the concept of inherent contempt. For most of modern history, Congress has relied on the Department of Justice to enforce its subpoenas. This system works on the assumption of good faith. It assumes that the Attorney General will respect the legislative branch enough to prosecute those who defy it. That system breaks down completely when the person defying Congress is the Attorney General herself. If Congress cannot enforce its own laws against the executive branch, then Congress ceases to be a co-equal branch of government. It becomes merely an advisory board. By dusting off the tool of inherent contempt, Representatives Massie and Khanna are attempting to reclaim the constitutional authority of the House. This is a power that has not been used in nearly a century. The fact that a libertarian Republican and a progressive Democrat are joining forces to use it signals a deep systemic rot. It shows that the breakdown of trust is total. They are bypassing the entire legal system because they believe the legal system has been captured by the very people they are trying to investigate. This is a desperate move, but it is also a powerful one because it attacks the personal financial security of the official. It changes the calculation from political cost to personal bankruptcy. Second, we must compare the Minnesota situation to historical precedents. We have seen conflicts between federal and state governments before. During the Civil Rights era, the federal government used its power to force states to comply with desegregation orders. However, that was done to enforce constitutional rights verified by the Supreme Court. What Bondi is doing here is the inverse. She is using federal police power to demand data that the federal government is not automatically entitled to, specifically voter rolls and state welfare data. This is a dangerous expansion of federal coercion. If the Attorney General can use the threat of armed raids to force a state governor to hand over voter registration lists, the balance of power in the United States has shifted dramatically. It turns the Department of Justice into a transactional weapon. It suggests that safety and peace in a state are conditional on whether the governor obeys the political demands of the White House. This is the definition of a protection racket. It is using fear as a control mechanism. The Atlantic's reporting on the firing of 230 career attorneys provides the necessary context for why this is happening. Institutions are made of people. When you remove the people who carry the institutional memory and the ethical standards, the guardrails vanish. The reason Bondi can send a letter that sounds like extortion is that there is likely no one left in her inner circle to tell her no. The internal checks and balances have been purged. This is similar to what happened during the Saturday Night Massacre under Richard Nixon, but it is happening in slow motion and on a much larger scale. The connection between the Epstein files and the Minnesota coercion is crucial. They seem like different topics, but they are the same problem. In the Epstein case, the Department of Justice is hiding information to protect the powerful. In the Minnesota case, the Department of Justice is demanding information to persecute the vulnerable. It is a dual use of information control. They want total opacity for themselves and total transparency from their enemies. This is a classic authoritarian pattern. It creates a one-way mirror where the government sees everything you do, but you see nothing the government does. We also need to analyze the reaction from the states. Governor Walz's refusal to comply is a significant moment of resistance. By linking the demand for voter rolls to the failure to release the Epstein files, he has created a political trap for Bondi. He is highlighting her hypocrisy. This suggests that the fear factor is weakening. Usually when the federal government threatens a state, the state folds. Minnesota is not folding. They are fighting back in federal court. This suggests that the perceived legitimacy of the Department of Justice is eroding. When states stop viewing the Attorney General as a legitimate law enforcement officer and start viewing her as a political rival, cooperation ends. The federal system relies on cooperation. Without it, the machinery of government grinds to a halt. Now we need to look at what comes next. The consequences of these actions are going to play out in the short term and the long term, and they will reshape the political landscape. In the immediate short term, the focus will be on the House of Representatives. The inherent contempt resolution is the key variable. If Massie and Khanna can get this resolution to the floor for a vote, it puts every single member of the House on the record. They will have to vote on whether the Attorney General is above the law. If it passes, the fines will begin to accumulate immediately. We are likely to see legal challenges from Bondi's team trying to argue that inherent contempt is unconstitutional. However, because this is an internal power of the House, the courts may hesitate to intervene. This sets up a direct showdown between the Sergeant-at-Arms of the House and the Attorney General. Regarding the Minnesota situation, we should expect a federal court ruling soon. The arguments filed by Governor Walz's lawyers are strong. If a federal judge rules that Bondi's letter constitutes illegal coercion, it will cripple her ability to pressure other states. An injunction against the Department of Justice would be a massive embarrassment for the administration. It would legally confirm that the Attorney General attempted to extort a state government. This would provide more fuel for the impeachment arguments. Long-term, the consequences are even more serious. If Bondi survives this without penalty, a new precedent is set. It will mean that Congress passes transparency laws that the executive branch can simply ignore. It will mean that the deadline for releasing documents is just a suggestion. It will also mean that future attorney generals can use federal agents as bargaining chips to get political data from states. The guardrails will be gone permanently. However, if the inherent contempt strategy works, it reestablishes the power of the legislative branch. It creates a roadmap for how Congress can fight back against an imperial presidency. It would force future administration officials to think twice before ignoring a subpoena, knowing that their personal bank accounts are on the line. We must also predict the reaction from the White House. The president is unlikely to back down. He generally views any attack on his subordinates as an attack on himself. We should expect him to escalate his rhetoric against Massie Khanna and Governor Walz. He may order Bondi to double down on the redactions or increase the federal presence in Minnesota. This creates a cycle of escalation. The more Congress pushes, the more the administration resists. The reality is that we are entering a period of high instability. The mechanisms of accountability are being tested to their breaking point. The Department of Justice has lost the trust of Congress and the states. Rebuilding that trust will take years, perhaps decades. For now, the system is in a state of open conflict. The outcome of the inherent contempt vote and the Minnesota lawsuit will determine who actually holds power in Washington, the people who write the laws or the people who enforce them. This is the moment where the theory of checks and balances meets the reality of raw political power.